Great, thank you. Good afternoon, welcome everybody. My name is Pauline Lane. I'm the professional lead for infrastructure at the Planning Inspectorate. And just to note that a recording has started and will be published after the event on our webpage. This is one of a series of seminars which we are giving. Again, we can give you a link to the webpage with all of the others on already, where we're hoping to both assist in influencing good practice across the system, and it's also one of our objectives in the strategic plan, of course, to improve the planning system as a whole. So we hope you'll find this useful at both the personal and the individual level, but also in future project planning as well. We're joined by three inspectors this afternoon. Two of them you can see on the slide and we'll be giving the presentation. That's Annie Coombs and Richard Allen, and I'll let them introduce themselves in a second. And we also have Rod MacArthur, who is an examining inspector, who is assisting us with questions and answers. The Q&A will be available. Please do feel free to post questions in it, and we'll give you answers immediately if we can, or we'll save some of them up for discussion at the end of the session, but we're not planning to take questions during the actual presentation. But what you can also do is you can also upvote questions. So do feel free to vote on the questions as you see them arriving. Hopefully you will have noticed that we published website advice pages last week, which supports all of this. That actually has even more detail in it than we're able to cover in the session today. And of course, you'll see that it's part of a series of additional items of consolidated advice, which we've published, which is intended to assist everybody involved with the process, statutory bodies, promoters and applicants, and also local planning authorities and people who wish to register on an individual project. So the only thing we can't do today is give a response that relates to an individual project that is currently in the system and pre-decision, as that would constitute advice for the purposes of the Planning Act and for which we have to publish on the advice register. So we will give generic advice and point to examples where we can, but please be aware that we can't respond to questions which relate to, as it were, live projects at the moment. So apart from that, we hope we're going to find this really helpful. We think it's good timing because we know that there are more linear projects coming through the system, particularly pipelines, electricity transmission and water transfer, which is a new part of the system. So we hope that this is a good time to have this session. So can I welcome Richard and Annie, and we're going to start with Richard to introduce himself.
Yes, good afternoon, everybody. My name is Richard Allen. I'm an examining inspector and an inspector with the Planning Inspectorate, where I deal with Section 78 appeals as well as hearings and inquiries. I primarily am focused on national infrastructure, and I have examined and made recommendations on a number of projects, including linear projects. Annie.
Hello, and I'm Annie Coombs, and likewise I've examined and supported a number of linear infrastructure projects in my role as an examining inspector. And when I sort of think back over my career, I sort of realised that I've worked on linear projects and linear infrastructure projects for quite a lot of the whole of my career. So this is the agenda, and we'll just have a very short section on key messages, and then I'll talk a little bit during that. I'll talk a little bit more about the three areas that we've divided this presentation up into, and then, as Pauline said, there'll be questions at the end. So this key messages. So we've corralled our thoughts from the advice note into under these three headings, and as Pauline said, there's more on the advice page than we've been able to cover in this, but also there's examples in this presentation that aren't in the advice page, so we're trying to widen the best practice that we're sharing with people. And so in terms of the three key areas that we're just emphasizing, all these three key areas relate to the fact that we're dealing with long, complex geography, which means more habitats, more people, more communities, more landscapes that these projects are going through. And so the importance of engaging early and constructively is one of the key messages that we're giving in terms of all those communities and affected persons, interested parties, etc., who need to be engaged with. Second area is the contextual understanding. So looking at where the connections are for whatever the infrastructure is and how it relates, and sort of really what the project is all about. And then the third area, which comes up probably on virtually every examination, is that flexibility. And whilst we as the inspectorate recognise that applicants have a need for some flexibility for lots of reasons, then just how that flexibility is communicated, what options have been looked at, and what level of detail is needed to secure that flexibility is something that we'll cover in the third section. And the aim of the advice note is very much about helping parties to recognise at what point they can engage and where they can assist. So this webinar and the advice note are very much not just for the applicant. They're there for interested parties of every type and also affected persons, who people with interests in land. And the engagement with the inspectorate from an applicant's point of view, then there's pre-planning. The pre-planning prospectus gives more detail on the different levels of support that are available. And it sort of goes without saying, really, but everything that we're saying is to be read in conjunction with the Planning Act 2008. And anyone who attended the Good Design webinar in December will, or has read the Good Design advice note, will recognise this diagram. And the reason that I've included it here now is because this shows the process that examining authorities will be looking for when they're looking at a project, to satisfy themselves that good design will result, that a process has been gone through. So that isn't to say that we need to see those precise words that are on this diagram, but just to satisfy ourselves that the process has been gone through. And the reason for including it here is because of the importance of the design process in linear projects, because of that challenge of the long geography that I mentioned when I was talking to the earlier slide, and the need for iteration, that views are received, and really also to stress the importance of early engagement. And then part of that process, environmental impact assessment, is a really important part of that iterative design process. And this is a diagram, I think, from one of the East Anglias, but just showing that the design iteration is there on the second bar of the turquoise diagram. But it's probably fair to say that we don't often see flow charts or diagrams where the EIA and the integration of the design process are shown in a sort of flow chart way. That could be helpful to see that. And in terms of likely changes coming our way, then it's going to be important to be very clear about beneficial outcomes. And there's a bit more in the advice page about that. And obviously, ones for linear projects, there's the potential for enhancing various networks, biodiversity networks, or public rights of way, etc. And in terms of the EIA and the environmental statement, then quite often we see these divided into sections. And if that's the case, then it's important that the section lines are done on a logical basis. So it isn't necessarily a local authority boundary. It might be looking at national character areas, and that rationale should be presented in the environmental statement. And this is a really good plan showing the different sections that were considered in the environmental statement coloured separately. So important to have a diagram or a plan that is very clear about how the environmental statement has been sectioned, if it has indeed been assessed in sections. But equally, it's important to give an overall assessment so that there's confidence that there's no gaps in the assessment. So I'm going to hand over to Richard, and he's going to talk a little bit about that engaging early that we've mentioned.
Thank you. Yes. So in the next few slides, we'd like to just talk a little bit about the pre-application engagement. and in particular to emphasise the importance and benefits of early and comprehensive engagement that the benefits can bring. For a linear scheme, there are likely to be lots of local authorities, lots of landowners, lots of interested parties, lots of affected persons, statutory bodies and local bodies alike. And so we would say it's really good and to get good proactive engagement, and that can save considerable time when the application is examined. Now, the National Infrastructure Commission accepts that there will not always be agreement in schemes, particularly linear schemes, and also recognises that there may be tensions. And it's somewhat, in a way, understandable that where parties involved in linear schemes may feel that pre-application discussions or constructive engagement is perhaps a little unnecessary because people do object and people are concerned. But actually, the opposite is true. Early and continuous engagement is actually really important and can help and assist in alleviating some of those concerns and certainly making for a much smoother application process and examination time. And just to give you an example here, linear schemes, as I said at the outset, can involve considerable numbers of parties involved. The graphic you can see on the screen is Southampton-London pipeline, which I've referred to a few times today. But this is an illustration of the extent of the route. In this case, it was nearly 100 kilometres long, running from just outside Southampton to the Heathrow Airport boundary. Now, there were along the route 9 district and local authorities whose boroughs, administrative areas this route ran through. There were 2 county councils, the South Downs National Park, the Greater London Authority, and 1 London borough. And on top of that, there were over 2,000 plots of land identified in the land plans and in the book of reference that the applicant needed to gain powers over. So that just gives you, in this case, the extent to which these schemes can engage the number of people involved. And so therefore, it's pressing again on the importance that early consultation is given and time is given to reach the agreements or not agreements, as the case may be, and to identify the issues that can assist the examination process. Now, there are various ways in which you can engage with authorities and the public alike. And I just want to say a few words on this. I think it's important to consider the appropriate method and best illustration that a proposed development will be and the effect it will have. And as said there, you can deploy various methods through fly-throughs or models, which are always very helpful over and above the technical drawings and engineering drawings that obviously that will be produced as part of it. And just to go through a few examples of that, on a scheme, a linear scheme that I dealt with a number of years ago, the applicant actually engaged or sought to engage a trusted local expert, a person that was known and trusted by the farming community and landowners. And by doing that, that actually gained their trust. It gained a lot of confidence in that system, in the application, and whereby it was much easier to negotiate with them. On another scheme, on Eggborough Power Station, which is not being built, the applicant did a fly-through of the high-pressure gas pipeline, but they did that very early on, and they took that to pretty much every event that they went to in the pre-application discussion and local events and stuff. And it was available on screens throughout the examination, the pre-examination process, the preliminary meeting, and all the hearings that we had. It was there with a person to take the members of the public and others through it so that they could understand what was actually happening. But I do want to stress that one of the important ways that you can engage, or engagement can take place, is via a really good interactive website. And again, drawing on from Southampton London Pipeline, in that experience, the applicant had really given a lot of thought and put a lot of resources into an engaging website. So not only did it contain videos and fly-throughs, but what was really helpful is that it contained an interactive map, allowing users to understand where the route was going, to be able to put layers on that map, such as constraints of conservation areas or listed buildings or other designated sites. You could also, in this case, put your address in, and the public could put their address in and actually see where their property is in relation to the proposed development in this case, and how they related to it. And in some cases, in a lot of cases, the planning inspectorate can reference the developer's website to help explain the proposed development. So this was actually what you can see on screen was actually an explanation guide that was produced on how to use it. But it was a really good example of a really engaging website, again, to help explain the proposed development. In the next few slides, I'd like to just talk go through a few examples of how, through that early engagement and constructive engagement, how changes can occur to an application. And in fact, that's the best place to do it, because the implications at examination stage of changes are much more difficult. And I'll say about that at the end of these slides. It can also have an effect where a party initially objecting to a scheme can actually then look at specific routes along land and actually identify where specific objections are. So in this case, this is just as I say, just a few examples here of where, in this case, where a landowner initially responding to the proposed development didn't had a concern about the existing the proposed route at the time, which is the sort of grey lines route here, and through the applicant taking a positive approach, managed to identify a new route along the person's land, again overcoming the concern that was raised. And this doesn't just extend to landowners. In this case, statutory bodies and others can also have an influence, again, where there's initial concern about the proposed development taken as a whole. Through that engagement, you can actually really go down to where the actual concern is. In this case, you can see here that a concern was raised about the effect on an ancient woodland, and the applicant was able to deviate the line away from it, again in the pre-application arena. And also, again, on this slide, again, another example of where the line was moved as a result of those early discussions. The local authority, again, can influence a move. And again, here, just another example, again, of how the route was moved over biodiversity concerns. And again, through a pre-application stage. And the final example that I want to use on this is on the A66. And this is a change that the local community were able to influence over. So the A66 currently runs along here and along this grey line here. And the initial proposal, the initial pre-application, was to dual the various sections of the A66. But here in particular was to actually go to the south of a settlement called Kirby Thor and realign again where it is already dualled. But the local community were very concerned about the effect it would have on the village, particularly the area to the south of the village, because that's where many of the historic assets were, and listed buildings, etc., and scheduled monuments. So again, working with the community, the applicant devised the probably a more costly route. It was a more costly route to them, but actually deviated to the north of Kirby Thor again as a result of those communications with the local community, and then alleviating a concern that they had. And as I say, what these examples show is that by doing it early on, the implications are less than doing it within an examination, because if you're doing it through an examination, then things like the order limits may have to change, the book of reference may have to change, the CA compulsory acquisition regulations may be engaged, all delaying an examination. Linear schemes can also, or very likely to, encounter the Equality Act and protected characteristics, and regard must be had to those as well. And again, the photograph shows, again, drawing from the A66, the existing single carriageway road runs just along here, and the area in blue is the Brough Hill Horse Fair, which is a gathering of the Gypsy and Traveller community at the end of summer. But nonetheless, they have actually a royal charter to be able to hold their horse fair in this area. And the applicant, again, had very early discussions with them. The royal charter prevented them from actually moving the site too far away from where they were at the moment. And various sites were looked at and discounted in consultation with the Gypsy and Traveller community, so that the land in red was identified as the site that was preferred. And again, this is a good example of early engagement. And just to on this, is not just the larger bodies that should be considered, such as the Gypsy and Traveller community. Individual persons need to be considered as well. This same applicant arguably didn't quite show the same duty to older persons along the route, particularly a couple that was largely surrounded by the development, and changes had to be made during the examination in order to comply. So it's not just larger groups.
And I think it's also not always the case that the applicant will have public sector equality duty. So if it's not a local authority, or in the case that Richard was talking about, highways. So in terms of where the applicant doesn't have that public sector equality duty itself, it is really helpful if applicants can support us at the Inspectorate in terms of our duty, and ultimately the Secretary of State. So, for example, on Yorkshire Green, then there was a traveller's site within the order limits, and we had a lot of support from the applicant there in terms of liaising with the travellers' agents and ensuring that there was representation at the relevant hearings and the like. So that supporting in terms of ensuring that engagement takes place is important. And I think that another key point is the importance of ensuring that those persons with protected characteristics are assessed in the correct way within the environmental assessment. So attributing them with the appropriate level of sensitivity when, for example, noise or landscape visual assessments are being undertaken. And so just moving on to really sort of the whole process of engaging, and I'm sure to many, when we're sitting there in our black dark suits at hearings, then we probably don't appear that human. And so it was quite refreshing after a long day's accompanied site inspection to be told you're more human than I thought you'd be. And this was a landowner, farmer, who had made an objection and who pointed out some really important key things to the XA when the XA was on site. And I think that importance, we can't overemphasize the importance of listening and understanding other parties' perspectives. And applicants won't always come to the same conclusion as those who are engaging with them want them to come to, but just making sure that process is constructive and this listening is taking place. And I think I'll just let you read this closing statement from a parish council, and really I can't imagine that anyone really wants to end up with this sort of closing statement. But the parish council makes two really important points, and the first one is in the first paragraph, where it's saying it could have been an opportunity to cooperate and secure a better solution. So they were saying that there were opportunities that could have been handled differently. And in the final paragraph, where the parish council is absolutely right regarding the construction stage and the need to continue to work with communities during that construction stage. And one thing that can be quite important in this is the role of an agricultural liaison officer, for example. I mean, sometimes they call different things in different DCOs, but on Yorkshire Green, there was quite a bit of time spent finessing the role description for the agricultural liaison officer, understanding that it was a role and not one person, because the linear project, you're likely to have activities going on at different parts of the alignment at the same time during construction. And that sort of more detailed description of the role of the agricultural liaison officer and securing that within a document that was then secured in the DCO even led to the withdrawal of one of the farming objections. And even with the sort of massive advances that we've got in AI-powered construction scheduling software, then that'll help with the sort of programming of the works, but there still needs to be that person on the ground to talk to the local people and the local businesses. And Richard gave an example of that earlier in what he was talking about. And another point really is about giving people, particularly local communities, clarity on what they can influence, because there will be areas for technical reasons that can't be changed or influenced. And so that clarity is just, I think, an important part of the process of engaging. And so on these are the T-pylons on the Hinckley connector that goes from Hinckley Power Station up to South Gloucestershire, north of Bristol. On that alignment. And during the examination, there was discussion about colour of the T-pylons, and it was very important that that colour was secured in the DCO because, well, the next slide will show, but that alignment was going through 5 or 6 local authority areas. And so the discussion about the colour took place with some parish councils using colour boards out in the landscape. The overhead line was going to go through, and that was quite an important part of establishing what colour was required. So giving local people the opportunity where relevant. And another example is on the Norfolk Boreas offshore wind farm. Then that DCO included a process for a local design review process for local people to be engaged, local landowners, for input on the converter stations, and that was secured in the design and access statement. And when it comes to colour, then just sort of noting that the two pictures on the right were taken from exactly the same location, looking in 2 different directions, but depending whether the sun was in front or behind, so that the colour changes, weather has such impact on colour. And then joint working is another area that can be really helpful for examining authorities. So this is the alignment of the Hinckley connector. So passing through, first of all, South Gloucestershire, Bristol, North Somerset, Sedgemoor, and then West Somerset districts, and of course Somerset County as well. So all the local authorities had worked together during the pre-app stage. I think there had been a PPA to support that process, and they represented themselves in the examination as the joint councils, and they appointed counsel for that engagement, certainly at hearings. And so that was really helpful in terms of recognising that the the opinions of those councils were coming from one body. Now, that isn't always possible. For example, on Yorkshire Green, there was a local authority reorganisation during the examination, and so that would that hampered any potential for joint working. But even if there isn't a sort of bringing together of all the councils in one, it is helpful if agreements can be reached on topics that are really sort of project wide. So for example, on the Yorkshire Green project, then there wasn't agreement between the various local authorities on working hours, greenbelt matters, landscape maintenance periods. And so if it is feasible to bring those local authority views together, then that helps. And the longer the project, the more local authorities are involved, and the more time that can be taken up in examination and recognition and the recommendation stage if the views aren't aligned. Now, we acknowledge they're not always going to be aligned, but that is helpful. And it's not just local authorities. There's, internal drainage boards, other statutory consultees, and such statutory undertakers. So the list on the left-hand side of the slide. And then this slide is definitely aimed at the applicants, but what we're asking for now, as I'm sure those of you who are online are engaged with us at the moment, then we are asking for a land rights tracker. And this is particularly important on linear projects because the large number of plots that are likely to be the case. And so the slide is showing the columns that were required in terms of the information to be provided on a recent land rights tracker for what was quite a complex project. And we acknowledge that this tracker should be proportionate to the complexity of the project. So if it's Excel or something similar in terms of the tabulated information, then it's important to discuss this at pre-application stage with the inspectorate to get a feel for how much information is needed and how many times it might need to be updated during the examination. And whilst this is stating the obvious, the more that's agreed before the application goes in, then the less work for the tracker. And then this is just an example of where possibly some agreement earlier on might have meant that an objection wasn't required, and that the order limits would have been in a slightly different place. So the red is showing the order limits from a road to give access, construction access to, and actually maintenance access as well, to a corridor. And this is a cattle yard here, so farm buildings around with a cattle yard. So the order limit track, the access track, took 3 right-angled bends through a cattle yard. And the objection, which was a constructive objection really from the landowner, the farmer in this area, was basically saying, can we not look for a voluntary agreement to take a route that doesn't go through my cattle yard? And we didn't see the alternative, but we were advised that there was constructive discussions going on between the applicant and that farmer. But the point of this is that if the landowner had a better routing, then perhaps that better routing could have been included in the application. And then the objection and the need, if you've got a tracker for tracking that objection, would have disappeared. And then just moving on to another example where there was access needed to a haul route. So there's a haul route down right-hand side of the slide, and then the access was from quite a way off on the left-hand side. So the red line is showing the what was the proposed access track to the haul route. The yellow is a residential farm, which was very close to that access track, very small garden, and family with young children living here. And then these are the farm buildings. So there was a lot of movement that took place on a daily basis between the yellow and the red and the blue circles. And the sort of proximity of this only really became apparent to the examining authority during an accompanied site inspection, which was probably halfway through the, or maybe a third of the way through the examination. And because it would have meant different land rights and looking at different alternatives, then there wasn't time during the examination to find a suitable alternative. But what was included was a bespoke, the need for a bespoke traffic management plan to be agreed with the local authority prior to work starting in this area. And what you can see, this is an aerial shot from Bing, and what you can see is that must have been what the alternative routing that was agreed. So they went round the back of the farm stead buildings. And if you look on Google, then most of this area is now green. You can still see a slight alignment of where the access track went. So just again, the value of identifying these issues and then resolving them earlier on. And now I'm going to hand back to Richard.
Thank you, Annie. Yes, and I just want to finish this section with a couple of slides on statutory undertakers and drawing on the matters that could be resolved earlier in the process. Now, as set out at the beginning, that linear schemes will very likely encounter many statutory undertakers, those providing road or rail infrastructure, water bodies, electricity and gas suppliers, to name but a few. And it's quite important that those statutory undertakers are identified again very early on in the process, and also what's identified is particularly what the issues that are going to affect them, if any. Now, these are usually dealt with by protective provisions. Protective provisions are make up part of the development consent order that is sent to the Secretary of State. Now, applicants really should agree protective provisions as soon as possible and preferably before the examination begins. I think there's a lot of examples where it is left to the examination stage when meaningful discussions begin on this, and it can quite often take up much of the examination time and lead to it not being particularly smooth. Applicants will be aware, and others will be aware, that there are a number of orders now that the Secretary of State has made where they have agreed certain protective provisions for statutory undertakers in their orders. And that's really where the starting point should be, the orders that the Secretary of State has already agreed, with perhaps any specific changes or clear explanations made as to why in this case there needs to be a departure from that through an additional paragraph added in or a paragraph taken away. Quite often in examinations, the protective provisions that are old or from years ago are the ones that are the starting point, and they really shouldn't be, and they shouldn't need to be. This is a matter that needs to be discussed much earlier in the process, and as I said, the Secretary of State's already made a number of decisions on protective provisions for linear routes, whether they be offshore wind farms or cable routes or highway schemes. And I do just want to draw finally on the final two bullet points of this slide, and just to say that if protective provisions are not agreed by the close of an examination, it will be the examining authority will have to make a recommendation on what that wording will be, and therefore control of what that is passes from an applicant or a statutory party to statutory undertaker to the XA. Particularly when the Secretary of State does receive that, you should not expect the Secretary of State to undertake any further consultations on that. So again, there's another incentive really to deal with this and agree this much earlier in the process. Okay, Annie.
Thank you. So now we're just moving on to the section on contextual understanding. And I'm just looking at the clock and realizing that we probably need to speed our talking up a bit. But anyway, so this is just a very quick look at the Planning Act stages and the importance really of the sort of, importance of the pre-application processes. And then I'm just going to say a few words about the pre-examination stage, which is one of the ones that isn't in bold. So it means that isn't a fixed time within the Act. And that's an important time for examining authorities to be familiarising themselves with the documentation, with the site, what the project's all about. And so just ways to assist would be if applicants can possibly suggest route plans for linear unaccompanied site inspections, obviously only accessing by publicly accessible land, and other IPs in terms of their relevant representations, maybe mentioning places that that they would want the XA to visit. Now, often that's requested at a later stage in the examination, but just early indication of places that it's important for XAs to see would be helpful. And the photograph is of a field of oilseed rape in Kent, and this was part of the site inspection for the Richborough line, and we sort of crisscrossed the area where the route was planned to go, and just bearing in mind this one yellow field, and it was so helpful in terms of a sort of prompt to us as to sort of work out where we were. And later in the examinations, then there are real benefits in potentially pegging out areas, so to see widths of corridors or locations of the sort of more fixed parts of the infrastructure, and that helps as well, but obviously with the permission and support of landowners. So back to Richard now.
Thank you. So I would like to talk a little bit about public rights of way and non-motorised users and bridleways, and then I'm going to talk a little bit about how visuals can assist in understanding the context of an application. So here, I want to say that I don't think it can be underplayed the importance of linear schemes in considering non-motorised users and public rights of way, bridleways, and other footpaths used not by motorised vehicles. In fact, this is a requirement of EN1, the national policy, for projects to consider this. And I put on a slide here, this is a visual of an example of a reconnection of a public right of way. This is the M25 junction 28, which is currently being constructed at the moment. The M25 runs in this direction, here, and this is the A12, which runs along here and then goes up that way. Now, currently, just a little bit about this scheme. Currently, the footpath runs alongside the A12 on slip. This is heading towards London, where you walk up and you cross. You have to cross currently the M25 off slip, which is okay because the vehicles are slowing down at that point. You then go into an area which I can only describe as hostile or quite unsatisfactory here, before you really are taking your life in your hands here when you try to cross this section. This of course is the on slip to the M25, so that crossing there is quite dangerous before you come to what is an original road, the original A12 road here, Brook Street, along which now arrives at the roundabout. So the applicant's proposal here was to reconnect the public right of way, but actually provide a new one within on the north side of the roundabout, which is actually a much better space, albeit that it's underneath the M25. It is actually a much better space. But the issue here was the fact that this area and this area were outside of the order limits. This area being controlled by Essex County Council and this area by Transport for London. And so the challenge here was to how to deliver the set of improvements when you have three different bodies involved. and we managed to do that at the end, where the applicant would deliver their section and fund and devise a scheme and fund the two elements either side, but it would be for those bodies to actually undertake that work. And I believe that is being done as part of the construction works which are currently taking place. And so this is actually a really good example of of schemes. Well, this isn't quite a linear scheme, but it is a scheme nonetheless that thought about and connected up the public rights of way and the footpaths. And just to say as well, this is very much an issue on current casework where that hasn't quite been done as effectively. So on the next few slides, I'd like to talk about the usefulness of diagrams to assist in context and understanding an application, having regard to the fact that not everybody who is involved in an NSIP is technically minded and will understand technical plans or engineering plans. So just looking on a wider context, this is taken from the HyNet carbon dioxide pipeline. And the drawing is just to show how the scheme connected in with other projects along the way. So just understanding how it fits with other schemes. And the XA found this a very useful diagram in explaining that. And from the A66, this is a simple diagram, a map that was produced by the applicant, identifying where the relevant representations came from, almost like a hotspot map. Now, this is useful for a couple of reasons. Firstly, to identify, of course, where there is perhaps a concentration of concerns raised or interest raised from the public and others. But it's also very good for the XA in being able to identify quite early on where perhaps unaccompanied or accompanied site inspections need to take place, but also particularly where events should be held, such as the preliminary meeting and other hearings, in order to ensure that the public don't have to travel so far. So this is a really useful map diagram in that respect. And again, just the next couple of slides on useful diagrams to explain the context of the works and particularly the amount of land needed. So again, this is taken, the two diagrams that you see here are from Southampton Pipeline. The top one being where they were using open cut method of construction, and the other one the one below, which is a trenchless crossing. Now, taking the first one can see that the actual pipe itself and the trench to go in isn't particularly very wide, but the actual order limits is much wider than that, and it shows why. For again, understanding your audience and others who may not be who have come across an NSIP before and may not quite grasp the technical drawings. So here it shows quite clearly why the land is needed. So we have construction vehicles actually doing the work. There's a haul road. You have areas for topsoil and subsoil, and then the protective fencing to protect the works during construction. So that's a very easy and good diagram to use. And essentially the same for the bottom as well. Again, the water course in this particular example isn't particularly very wide, but the order limits there are quite wide, and that diagram explains why. The process of doing HDD or other form of trenchless crossing is quite land heavy. The land is needed either side to push the cable or the pipe through that. And this is taken from a offshore wind farm, and again at the landfall point, explaining, again showing that where cabling comes from the sea and arrives at landfall, again quite a lot of land being taken for that, and just explaining why that's necessary. Good visuals that really do that job and really help explain it. Now, I personally haven't come across this particular plan, but it was produced for the Net Zero Teesside project, and one that the examining authority found extremely useful in, again, justifying the amount of land that was needed for the project. But this is actually done by the plot numbers, and you may be able to see on the graphic here that the plot numbers are identified at the top, the colour coding being the power sought over that land, the yellow being temporary possession and blue being compulsory acquisition of rights. But then underneath that, you've also got the widths as well. But underneath that, you've got the actual uses for the land as well. So that you can see it says things like grassland, shrubbery, and the width for the pipelines. So it's, again, the XA found this really helpful in understanding from a CA point of view the cross section of why the land is needed. And again, visuals to help in the understanding of the context of the scheme. And I'll hand back to Annie.
Okay, Richard, we've got 10 minutes to get through the rest. So this is a really helpful diagram, the cross sections of an overhead line. This was the Yorkshire Green Line, and the different coloured pylons, which were showing pylons, new pylons, existing ones to be removed. And then equally, these sections related to the sections within the environmental statement showed the voltages, the substations, and where third-party undergrounding was going to be required. And so just getting a sort of feel for the picture, and you could stick them all together and have a big long line of plans, and that sort of information is helpful for XAs, but probably helpful for consultation stage as well. And then in terms of interactions, a linear project is going to, the longer the linear project, then the more likelihood of interactions with other NSIPs. And one of the areas that is arising more frequently now is the matter of co-location of substations. And this arose on the Norfolk Boreas and Norfolk Vanguard co-location of both substation and converter stations. This is an image from the Norfolk Boreas design and access statement showing 2 converter stations for Boreas and 2 for Vanguard. And the point to make here is that the Secretary of State amended the Norfolk Boreas DCO to include an onshore project substation master plan, which had to be informed by strategic approach to mitigating the cumulative effects of the 2 offshore wind farm converter stations, and also to include the outcomes and recommendations from an independent design review. So just thinking about the interactions and the need to think about them early on, and there's more about this particular topic in the advice page. And let's hope that they don't look like that. And I can't resist putting in a couple of slides that are demonstrating good design. So this is a substation in Finland, and just recognizing what NPPF says about high quality design and the like. And then again, that substation in Finland in the context with the terminal pylons. And the point about this isn't that this is what we should be building in the UK. The point about this is it's drawn from traditional Finnish vernacular. And so it's very much an example of excellent placemaking, drawing from the context of what's there, drawing from the sort of historic vernacular, and then replicating that in a contemporary way, using contemporary materials. And then just very quick slide, you've seen T-pylons before, but here we have a result of a British design competition, the T-pylons that carry the power from Hinckley, or carry the power from Hinckley up through Somerset. And now moving on to, this is the final section on flexibility, and Richard's going to talk to the first slide on this.
Yes, thank you, and I'll try and speed up. So this final section, we're going to look at some flexibility against certainty and trying to get that balance right, recognising, as we said at the outset, that the applicant will wish to have a degree of flexibility to construct complex and technically difficult projects against the need for local authorities and the public for certainty. Now, I'll make this one very quick. The how alternatives are explained is extremely important consideration for IPs, interested parties. Alternatives, particularly those advanced by a considerable number of interested parties, should be fully explained if they've been discounted. And again, this is a current cause of issue with current casework, particularly one scheme in pre-exam. I cannot underplay the importance of really clear visuals and justifications for the choice of route. Should be considered how alternatives are presented in applications and explained in the environmental statements. One example could be, as we did in slide 8, to break down the route and explain by sectionalizing it. Also, areas such as mini routing or measures to overcome particular challenges should be considered and explained why they weren't able to overcome the concerns and why a particular alternative over a wider scale was discounted. So this is a very important issue for the public who look at this, and has been a big issue on certainly a lot of cases. How back to Annie.
And so this is just looking at the areas where there's examination stage changes to limit that flexibility that we're talking about, which sometimes are necessary. So the photograph on the right is of the cable sealing and compound works area for the Hinckley connector when it was under construction. When you go up there now, you can, the cable sealing and compound is about there, and you really can't see much at all. But in terms of construction stage issues, then I think it's important that we give a consideration to that. Quite often, the local communities are very engaged about the construction stage effects that will be in their patch. And what happened on Norfolk Boreas was that there was quite a lot of flexibility in the locations of mobilisation areas, and construction compounds were identified, but there was flexibility about what would go on where. And having seen some of the sites and the proximity of local residents, then the applicant agreed and worked up more inclusion in the DCO and the Code of Construction Practice. There were changes to add more certainty to what would happen in those areas. So that included maximum footprint parameters for mobilisation areas, and that layout plans to minimise adverse environmental effects on sensitive receptors needed to be approved by the local authorities prior to commencing work in that area. And then here's an example of a pipeline. This is part of the high net carbon dioxide pipeline, which it had to cross a brook, and the applicant wanted to use a cut and cover. But Natural Resources Wales considered that this would breach the Water Framework Directive. And eventually, during examination, an alternative embedded pipe bridge crossing was put forward, and then NRW removed its objection. The point here is these sort of changes that occur during the examination. If these discussions can take place earlier in the pre-app stage, then it means that the examination time doesn't need to be taken up with dealing with these matters, and that's all in the sort of interests of expediency for examination and reporting, and equally decision time if things are left for the Secretary of State, which our objective more and more is that less is left for Secretary of State to consider or consult on. And then here's an example where just really showing the real importance of limits of deviation, and where the XA forgot about the importance of limits of deviation when it made a change in the recommended DCO. So we're considering pylon LD32, which is here. You can see from the turquoise line that the red line is with the order limits. It had already shifted a little bit to the west, and there was very extensive engagement by the owners and occupiers of this farmhouse here about the position with respect to their garden, and we had to consider the overbearing presence of the pylon on those residents. And the applicant was very helpful in providing some illustrating for us the different effects on moving that pylon a little bit further north or a long way further north. And we took the view, the XA took the view that that pylon would be moved by 40 meters to the north, and that's how it was written into the DCO. And unfortunately, when the undertaker came to construct, then the land on that particular point, that 14 meters north, wasn't suitable for geotechnical reasons to construct the pylon, and so the applicant needed more flexibility. And because of the way the RDCO had been written, then a correction order was needed. So the applicant had to go back to the Secretary of State in order to get that plus or 5 meters northwards. I think we've all learned from that, and just, you know, showing that XAs don't always get it right either. And then options, just a very short bit on options. So I think probably the sort of penultimate 2 points, you know, options take more examination time, and why wait if it can be agreed prior to the application? And if so, then there's real clarity needed on who decides and when. So the photograph is the second day of a 2-day hearing on the options for the Hinkley connector, and the options are in the advice note. There's a lot more about the type of options that can be included, so routing for the current or for substation types. And I think it's just a sort of discussion point for pre-application discussion about whether it's appropriate to be including options. Sometimes we recognise that the applicant needs that the options to stay within the DCO, but it does mean definitely more examination time and potentially more post consent time in terms of local authority or other organisations for post consent approvals. And this is, I think, my final slide. So just that in terms of the flexibility, it's really important to know what that flexibility is based on and what it would look like and what could be built within the parameters that are set. So you might get that flexibility described in design approach documents, parameter plans, construction environmental management plans. But the sort of importance of the worst case scenario, so and also whether the worst case scenario is actually ever going to be built. So this is a visualization of a new substation, and the infrastructure assets there are what was described as the most likely engineering scenario. But what had been assessed was the purple dotted line, which was the Rochdale envelope. And so, you know, potentially a lot more could be built. So just the importance of having that clarity, and the importance of reducing those Rochdale envelopes on occasion, if possible. And I think I'm handing back to Richard now.
Yes, thank you. And I've got just I just want to end on a few words on the balance as set out at the outset between flexibility and certainty. So again, drawing from Southampton London pipeline along a linear route, much of the land for the cable route was alongside open countryside, farmland, some distance from residential properties and roads. And in these locations, it may be appropriate to leave the detailed construction methods to detailed design stage when applicants have sought to have gone into much more detail. The difficulty lies is when applicants and others leave that or assume that to be for the whole of the linear route, and understanding the landscape and understanding the land needs to be a lot more clearer. So the picture on screen is of Queen Elizabeth Park. It's in Farnborough. The route is to go through the park here, and what we have here is it's surrounded by houses. It's greatly valued by the local community. There is a play park in there, but the area is primarily wooded. It contains a number of protected trees and a number of veteran trees in one particular, a very old tree, which is very valuable to the community. Now, in this location, I think it's fair to say that early in the examination, the applicant really didn't understand this area or how they were going to construct it. Again, relying on a we'll deal with that later viewpoint. We would say that that's simply not appropriate for these sensitive areas, and that applicants and others should actually identify certain areas where they need to take a bit more of a detailed and certain approach. The result here was that the applicant had to produce 9 what they called site-specific plans, areas where they needed to set out what those areas were, what defined their landscape character, what gave them their sensitive nature, and how they were going to construct the pipeline through there. And just the production of these documents, which went right to the wire, did actually give the community and the XA much more confidence about the how the scheme is going to be consulted in those areas. So this is about this balance of flexibility and certainty. And just the final message here is understand that linear routes go through different landscapes. Some are more appropriate to leave to a design stage. Others need information at the examination stage. And again, earlier identification of that and production of these early on in the process would have made the examination process a lot simpler and smoother.
Okay, so a very quick thank you for everybody who's attended and for listening. Hope it's been useful, and we're now going to move over to the questions, and Pauline will lead that.
And hopefully my microphone's come back on now. Sorry, I was just posting a link in one of the questions in the question and answers. So I'll just do that now because I hope it will be helpful. We have tried to give as comprehensive answers as possible in the questions, but do feel free to upvote if you still want a further answer. So I'm just going to rank the posts and see what we have still to go. Okay, a few more. We can follow these up as well with written answers too. But I'm going to take the first one on here, which I think is helpful as well. So first question is it time for an update to the Horlock and Holford rules that address newer technologies such as buried cables and converter stations? So if you haven't heard of the Horlock and Holford rules, these are approaches to the design of transmission structures, which came out of, I think, probably one of the earlier expansions of the national grid, which is actually, as you're sort of drawing attention to here, some decades ago now. And I think it's absolutely a good point that is being looked at. And I understand that as part of the Network Infrastructure Commissioner's Review report, which was published probably well over a year ago now, that there is a process going on called the electricity transmission design principles, which are aiming to have a look at exactly this point. So I don't know when the timescale is for any formal update to them or formal publication, but there is a process going on, and I suspect it will be linked off DESNZ's site, or possibly the NISO site. But if we can find a link for you for that, we'll post that in answer to the question. Right, can I share with Annie and Richard and possibly Rod as well? Do you have good examples of diagram map styles to show route and site alternatives that are clear to read? And I don't think that's necessarily a criticism of the slides. One of the challenges with PowerPoint slides is they make everything a bit smaller on screen. Hopefully those will be easier when you see the published version. But I think this is more about, can we link to examples which have already been published on our website at, as it were, full scale. So I don't know if anybody's got any particular preferences around good examples of diagram and map styles to show route or site alternatives that are clear to read?
I think there's a need for sort of different types. So obviously you need the works plans and such like, but what's helpful is the sort of the diagram that Richard showed for the high net carbon dioxide pipeline. So that just showed, you know, diagrammatically the Wirral Peninsula and that bit of the northwest, and few cities and towns located, and you could see where the proposed pipeline was going to connect in with other pipelines, future proposed and existing. And I think sometimes those diagrams are they've been used during consultation stage, so you might find them deep in the consultation report, but to have them up front in a non-technical summary or a design and access statement or a document that is part of the sort of more that isn't part of the consultation, shall we say, is helpful. So I think it depends on the type of infrastructure as well. But I mean, I personally find the cross sections, so the one with the pylons on, I find that sort of thing very helpful, just in terms of working. But that would never be something that would be secured in a DCO. That's sort of for illustrative purposes. I think probably we need to, I don't know, Richard might have some views on this. I can't think of any other ones that I would direct you to at the moment, other than to say, you know, the geography is important and the simplicity of the diagram is important.
No, I think you've said what my thoughts were, so I don't have anything further to add to what you said.
Pauline, I'm not seeing the same questions as you, so I don't know whether, are you on?
I think it may be to do with the ranking, so as to how
Okay.
they're coming in the ranking. So do have a
Yes.
look down the list as much as you can do. So Rod, I don't know if you wanted to say anything in the background, as it were.
I don't have anything more to add on that particular question, Pauline. No.
If we can think of some more good examples, we'll post those alongside this. Thank you. Quick one. Will the recording of this session be placed on the YouTube channel, as was done for the Good Design event? I think the aim is that we will publish as much as we can across different media, certainly on our website, but possibly on YouTube as well, for those who prefer to digest their information in that form, which of course is partly a generational thing. And yes, we're aiming to ensure that we keep up as much as we can do with people's preferred options for showing information. I'm just going to do, so Chris Mumby asks, as a statutory consultee, we hold a GIS, a graphical information system database, and often manually ask for the DCO order limits GIS files so we can accurately cross-reference and scope sites. If not, we can't always provide accurate, precise advice. It would be good practice to allow consultees to download and import layers from interactive maps. That's a really good point, Christopher. In the advice page, we actually do say that we would be interested in talking to applicants about receiving information in a slightly different range of formats, partly because the examining authority also find it helpful that they can look at layers of things. And it has formed part of the discovery that we have just undertaken as part of our digitisation work to look at options for applicants as to how they can format information in slightly different ways, which aligns with what people would already do for their project management approach anyway. So we're not going to be asking for new information. We know that people already have this information available to us, and we're keen to open up new means of publishing things. For those of you who are familiar with the detailed regulations, the application forms and procedures regulations are 15 years old now. They are somewhat clunky and very much related to paper-based systems. We are hopeful that there will be an approach to updating those, but in the meantime, we have the powers which were given under the local Levelling Up and Regeneration Act in relation to digital planning. So we aim to start utilising all of those approaches. So thank you very much for that comment. That was very, very helpful. Can I go to the next one down? I think Lucy Collins, and she has asked, linear projects can have a spread of environmental impacts over large distances on different habitats and species and across different landscapes. Absolutely. Have you seen any good examples of projects that have delivered a more strategic delivery of mitigation and compensation? That's a very good question, Lucy, and especially ahead of the potential bringing into force of the legal requirement for biodiversity net gain later this year. So anybody want to comment on that?
Had Rampin 2 been published, I may have been able to discuss that a bit more, because I think that was that might be one of where more strategic biodiversity net gain was considered. But as the Secretary of State still has that, I probably I can't say much more than that at the moment.
People can see the project on the website.
Yes.
As to what took place during the examination, but obviously we can't offer a view as to whether that's good practice. That might indicate something about the decision. So we're not going to do that, but no. You can see what was available there. Anybody else in terms of good examples? I do recall having a discussion with National Highways about the demand for personnel who would be able to undertake dry stone walling at the scale which they needed for the design elements of the A66, because that is one of the key things, is that that's an important part of the landscape in that area. It's important that new structures were designed using to show elements of that technique, and I had to deal with it myself when I used to deal with roads over the Pennines, and the availability of people to actually deliver that mitigation is quite a constraint on the system. So sometimes it's, you want to achieve something, but you also have to consider what skills availability there are to actually deliver those appropriate outcomes.
I think if we're talking about biodiversity in terms of that strategitic mitigation, then the sort of BNG will make a difference because it can be used as a reason for compulsory acquisition or for use of land. And so if we go back to projects like the Hinckley Connector, then there was quite a significant Section 106 agreement for delivery of what was referred to, I think, as landscape enhancement. And that was bulking up of hedgerows and providing more connections. And that was in addition to the mitigation that was necessary. There was some quite significant mitigation that was needed for bat flyways in one particular part of the routing. And so, but the landowner commitments to the actual use of land for that biodiversity enhancement, landscape enhancement, wasn't secured, and it was subject to future approvals by the local authorities. So I think moving forward with BNG gives more certainty to the specific location, and so therefore the specific way that it is addressing mitigation or compensation.
Great, thank you. Glenn Eden has asked a question about naming conventions in relations to parties under 42(1)(d). Can I suggest, Glenn, that I won't give a long answer at this point because it's a very specific point. We'll give you a written notification afterwards. But what we will say is that if you have a look at some of the most recent projects, which includes, for example, Immingham Green Energy Terminal, and then Gatwick Airport Northern Runway, which is still, I should remind people, in not a decision, it's a minded to, and also Rampion 2, which has not been decided, but you can see, as we noted before, the evidence and examination, you'll see there examples of the land rights tracker that was referred to in the presentation, and that shows our preference as to how information is set out in a database approach rather than the book of reference, and how that helps us deal with the different parties and the persons with interest in land, etc. So if I can refer you to those as being the most current versions, and that's our expectation of how we will take things forward. I'm just going to look further up. There's a specific question about, right. So Vicky Colwell has asked, is there or should there be a clearer hierarchy or weighting of the matters that have informed why one route should be discounted or forwarded within the alternatives? It's a very good question.
Perhaps yes. I think the way alternatives, in my experience, has been dealt with hasn't really hasn't used a hierarchy enough. I think I do think in increasingly alternatives is really being scrutinized by the public. They really are looking at not just necessarily where the route of a pipeline or a cable route is going, but in a substation location as well. And that was quite a big point on Ramping 2. That's in the public domain. That's very that's obvious. And it wasn't overly clear. The XA had to ask a lot more questions as to on alternatives that weren't really addressed. So my answer would be yes, there probably should be a clearer weighting with better explanations and drawing from those pre-application discussions with the community about what's important to them. Really, and that's where the focus in some places should be in respect to alternatives. Why certain routes or certain locations were discounted, but actually really going into explain that. Yeah, so I would say possibly yes.
I would say that I've seen reasonable explanations. I think it's a very complicated area to explain. And so therefore you often get a route optioneering report and then a sort of a series of reports. And so in terms of members of the public and other parties who aren't necessarily going to read every one of those documents, then the art is to be able to condense that into something that demonstrates that those that weighting process has effectively taken place in a sort of short, succinct précis, which might be contained in a different document. So I think probably the experience varies across different projects at the moment.
Right. Can I ask Annie and Rod if they'll have a look at the one from Camilla in relation to limits of deviation? And whilst you're doing that, I'll just draw together a few about BNG and the position that we consider biodiversity net gain. So yes, at the moment, I think there has been consultation in relation to the format of biodiversity net gain for NSIPs, but not yet the final guidance. We have said in section 51 advice, which is published, that for the moment, our understanding is that people should use the guidance that was published in terms of particularly the matrices, use the TCPA guidance for now. We're not aware of the moment that there'll be major changes in relation to NSIPs, and we've checked that position with DEFRA. So if you're not sure for the moment, please use the TCPA guidance. There's another one further up in relation to that.
Sorry, Pauline, I'm in most upvoted, but I can't see anything from Camilla. So are you in recent?
I'm in published. So
you've got a different.
So there is one from Camilla. I'll read it out. Can you please confirm that agreeing wording for limits of deviation is something that the parties can and should seek to agree ahead of submission of an application? So if you can respond to that in a second, I'll just finish off the biodiversity net gain ones at the moment. So the planning inspection, yes, is that we have seen several schemes which have offered biodiversity net gain provision, and that's included in some recent decisions. In terms of the form of it, again, not linear, but one of the recent solar decisions, I think Heckington Fen has got some extensive consideration of biodiversity net gain and how it was secured. It is probably worth making the point that whilst BNG is not a legal requirement for an NSIP at this point, therefore, if it is offered and in a sensible manner and is secured, then it can count as a benefit in terms of the weighting of the project. Once it becomes a legal requirement, then at least the minimum value of it forms part, as it were, the new baseline position and wouldn't necessarily count, therefore doesn't count as a benefit unless it goes beyond at least the legal minimum requirement, whatever that is and whatever form it's finally established in. So I thought it was worth making that point. There's a comment in here, starts about BNG. We see Matt, you've raised, Matt Parker Wooding, a lot about BNG and offsetting loss of ecology and biodiversity. Will there be anything to combat loss of the historic environment and archaeology? And I'm going to ask Richard to consider that for a moment, if you can see it, if you want to come back on that one. There's one from Andy Gregory. You mentioned the importance of making sure, as far as possible, issues are addressed prior to examination, such as the high net pipe bridge. However, how do you suggest applicants respond when issues are not raised until after the examination has started, and especially when consultees have had numerous opportunities to raise issues during consultation and expert sessions? So the answer to that, Andy, is that obviously those circumstances will depend on, one, not everybody will have necessarily been involved in every part of pre-application, but it is absolutely, as you've heard today, our suggestion is that pre-application is the right place to raise things as much as possible, especially if you want them to be potentially integrated into the design. If matters are raised at a later stage, such as during examination, obviously matters can be raised in the relevant representation in the pre-examination phase. If people don't raise things until much later in the process, then such as examination, then it becomes increasingly difficult for them to be taken account of. So I think all we would say to parties is please do engage in the process as early as possible and offer both your critique but also your ideas, because if the project goes ahead, and it might still go ahead even if you don't like it, then it's still better for everybody if you've actually been able to put in ideas which have actually potentially improved the situation. So all I would say to people is offering constructive suggestions does not take away from your right to critique a project, but offering constructive suggestions as well as any critique might actually assist in a better outcome than would otherwise be the case if you leave it too late or don't say something. So all I would say is we are fully aware that the later something is raised, the more difficult it is to be feasible, and that would be a matter which the examining authority would have to consider on a merits basis, but accepting practicalities of matters which could potentially impact wider powers within the DCO, for example. Can I just come back to Annie on the limits of deviation question?
Yeah, Richard, just if you go to recent posts, then you'll find the ones that Pauleen's looking at. So yeah, in terms of limits of deviation, then my experience is that they are the wording about the limits of deviation is usually in an article, and that's something that on occasion is discussed in examination. So I think it's important that it is that the wording is defined there, and yes, if parties have contributions to make with regards to that wording, then yes, it should be discussed earlier. But I think what's also often discussed is where those lines are on the plan, and I think it's helpful to have explanations as to where limits of deviation need to widen and where they've been narrowed for the purposes of protecting, say, a particular bit of habitat or archaeological feature or whatever. So it's sort of, I think the wording in the DCO is quite standard, I would think. And it's how they're drawn on the plan that's important and what they mean. And certainly during examination, then XAs will take evidence about the locations of those limits of deviation on plan and whether they are in the right place. I don't know whether that helps.
So I think apologies, we'll have to stop the questions there because we're literally about to go into time. We'll try and answer any remaining ones in writing afterwards.
Yeah.
Just a reminder on a couple of things. Please do complete the evaluation form. There's a link at the top of the questions, and we're keen for ideas, both for feedback on this session, but also ideas for future webinars and advice pages. We want a reminder that I think there was a link to the actual advice page as well. There is a forthcoming webinar on rights of way cases taking place on Friday, the 11th of February. But that will be recorded if you're away for Easter. And then I finally want to say thank you very much to everybody who's attended today, the questions, the contributors, the behind the scenes team, including the comms team, who have been absolutely brilliant in getting all of this done, published and up to date. And thank you very much for your attendance. I hope it was useful. Enjoy the rest of your day.
Thank you.